14, 20, 25 years in prison. The crime? Writing, owning books, speaking out. That is what today's episode is about, and let us say it plainly from the very first minute.
And with one feature we will not hide. There was no violence here, no weapons, not a single death. What a court called a crime was, word for word, the exercise of freedom of expression.
I am Tatiana, our legal analyst is with me, and this is the podcast of the Cuban Observatory for Human Rights. We continue our series, analyzing one by one rulings against Cubans in the light of international law.
Today it is ruling number 1 of the year 2003 from the Provincial People's Court of Camagüey. It is one of the trials of the so-called Black Spring, the March 2003 crackdown on the Group of 75.
Before we begin, the document reads well, so here we do have concrete facts. Tell me who the defendants are.
4 men from Camagüey: Normando Hernández González, a journalist, 32; Mario Enrique Mayo Hernández, a journalist, 38; Alfredo Manuel Pulido López, a dentist, 42; and Alejandro González Raga, a human rights activist, 45.
And what are they charged with?
All 4 with the same offense: acts against the independence or the territorial integrity of the state. Article 91 of the Penal Code. It is one of the most serious criminal charges that exist in Cuba.
Let us go to the sentences, because they are staggering.
25 years for Normando Hernández, 20 for Mario Mayo, 14 for Alfredo Pulido, and 14 for Alejandro González Raga. And note this, the prosecution actually asked for life imprisonment, a life sentence for journalists.
Wait, life in prison for writing?
It is stated in the ruling itself. The defense had to fight just to have the life sentence turned into a fixed term. That is the starting point of this trial.
And all of this, moreover, in a summary proceeding. Explain what that means?
It means an ultra-fast trial. The arrests happened in mid-March 2003, and this ruling is dated April 4th. In a matter of days, they investigated, tried, and handed down sentences of up to 25 years.
And what is the legal problem with speed?
The International Covenant on Civil and Political Rights, in its Article 14, requires adequate time and means to prepare a defense. A summary trial with sentences of this magnitude gives neither time nor means. Speed was not a guarantee. It was the instrument of punishment.
Let us look at the facts the court declared proven. What did these people actually do?
Here is the key to everything. If you strip the political adjectives from the ruling, what remains is this: they did journalism. They sent news and reports to outlets like Cubanet, Radio Marti, or Nueva Prensa Cubana. Normando is charged with 116 items of reporting.
And what did they write about?
About the real life of the country. Mario Mayo signed articles with titles such as, I quote, "Young man dies from medical negligence," or "Mother of political prisoner cries for help." In other words, they reported on healthcare, on justice, on the situation of prisoners. Journalism.
And what else counts as a crime?
Owning books and publications. One had 157 seized, another 272. Attending the opening of an independent library. Collecting human rights complaints. González Raga had 459 seized. Assisting political prisoners and their families.
So, having a library and documenting abuses.
Exactly. And one more thing, receiving money and aid from abroad. But look at the amounts because they dismantle the narrative. We are talking about $3,000 here, $600 there, a $90 parcel. Modest remittances, radios, a fax machine, a printer, medicine to hand out.
With that, the court builds a crime against the territorial integrity of the state. How does it make that leap?
With a chain of cause and effect that honestly does not hold up. The court says that reporting was meant to get Cuba condemned at the Human Rights Commission and that this would open the door to a foreign armed intervention. From a news article, they jumped to a military invasion.
That is an enormous leap.
It is pure conjecture. What is punished is an imputed intention and a remote consequence that never happened, not a real harmful act. There is no victim, no material damage, no violence. There are words and papers.
Let us get into the fine legal analysis. First problem, the court itself.
This ruling does not read like a judicial decision. It reads like a political pamphlet. In the 5th finding, the court starts praising the commander-in-chief and calls him, I quote, a great chess master.
A court writes that in a ruling?
It does, and it calls the defendants inept, mercenaries, and says they are neither combatants nor patriots. A body that writes like this has already prejudged. It violates, at its root, Article 14 of the Covenant and the UN Basic Principles on the Independence of the Judiciary.
Because an impartial judge does not insult the defendant,
He does not insult him, nor does he make propaganda for the power that appointed him. There is no independence here, not even the appearance of impartiality. It is a state security court applying the logic of the internal enemy.
Second block, the rights being punished.
What is punished is freedom of expression, of the press, of assembly, and of association. Articles 19, 21, and 22 of the Covenant. To report, to own books, to gather, to associate. These are rights, not crimes.
And denouncing abuses before international bodies, is that also a right?
It is a right expressly protected by the UN Declaration on Human Rights Defenders. Turning to the Human Rights Commission to report abuses is protected. Here instead, that becomes the heart of the crime. International law is turned completely upside down.
Third block, the proportion of the sentences.
14, 20, 25 years for writing and owning books is manifestly disproportionate. And to inflate the sentences, the court uses ideological categories: high social dangerousness, deficient social conduct, recidivism.
Social dangerousness. That phrase sends chills.
It punishes what a person is presumed to be, not what they have done. And as an aggravating factor, they use records that have nothing to do with violence. Against González Raga, they dig up an old case from 1995 for receiving and hoarding goods, punished only with a fine, mere survival offenses of the special period.
Fourth block, the evidence. What is the conviction based on?
In large part on a state security agent infiltrated into the groups, whom the ruling calls, I quote, an irrefutable witness, and on the statement of the police interrogator. No independent court would accept that as central evidence without serious adversarial testing.
And they say the defendants acknowledged the facts.
They acknowledged in part that they were journalists and activists. But that is not confessing to a crime, because doing journalism is not a crime. What is only an admission that you exercised your freedoms is dressed up as a confession.
And there is one final detail that, personally, shakes me.
The ruling orders that all the books, magazines, and pamphlets be handed over to the Ministry of the Interior, literally, for their destruction. Hundreds of books. It is a book burning by judicial order, and they confiscate the typewriters, the radios, the printer, the tools of the trade.
Destroying books in the 21st century.
It is material censorship. It is the punishment of thought. And all of it, moreover, in a trial that calls itself public, but that, in practice, was held behind closed doors, with no press, no observers, no relatives.
Let us wrap up. Sum up the errors and excesses of this process.
A biased court that makes propaganda instead of judging, a summary proceeding with no real defense, a criminal statute used as a gag, an imaginary chain of cause and effect, from the article to the invasion, disproportionate sentences with life imprisonment on the table, and add ideological aggravating factors like social dangerousness, evidence based on the infiltrator and the interrogator, and the destruction of books and the confiscation of the tools of the trade. Altogether, it depicts not a trial, but an act of repression in robes.
One note that gives all of this meaning: these 4 men are part of the Group of 75, recognized as prisoners of conscience. Most were released and forced into exile years later.
And there is a detail that closes the circle. One of these 4 convicted men, Alejandro González Raga, is today the executive director of the Cuban Observatory for Human Rights. The ruling we have analyzed is the living memory of repression.
Thank you for joining us. We analyze these rulings so they are not forgotten, and so it is clear what was punished and by what measure. You can find us and our reports at observacuba.org.
Until the next episode, let us take care of ourselves and take care of memory.